This hearing is in the matter of CFI 048 2017 before Justice Sir Jeremy Cooke and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Richard Little, QC. The first defendant is not present. The second defendant is represented by Charles Russell Speechlys LLP. Lead counsel is Stephen Doherty.
Thank you very much. Yes, Mr. Doherty, it's your application.
Yes, good morning, Your Honour. Thank you. As you'll have gathered, this is the second defendant's application to discharge the injunction order that you made some time ago on the 21st of October 2017. Hopefully, Your Honour will have had the opportunity to read the detailed submissions set out in my skeleton, and you'll have seen the grounds on which the application is made. Essentially, we make 3 points. The first is that the direction that this case has taken over the last 3, now coming on 4 years, demonstrates that there's no serious question to be tried. We know that because in all that time, Sunteck has not pursued any substantive proceedings, whether here in the DIFC or in any other jurisdiction, in relation to the parties' rights under the escrow agreement. And I'll come to the terms of that in just a little while. The second point that we make is that damages are an adequate remedy in any event. And again, we know that because the only substantive proceedings brought by Sunteck are foreign-seated arbitral proceedings where the primary remedy is damages. And Sunteck has not sought to claim any declaratory or relevant permanent injunctive relief, which has any bearing on the interim injunction granted back in October 17 or in relation to the escrow agreement. And we say that alone is grounds for discharge. And the third point we make is that the balance of convenience has shifted quite considerably since October 2017, so that now there's no reasonable basis for the court to favour an approach which holds the ring. And Your Honour will have also noted from my skeleton that we make an overarching point that there has been a material change of circumstances in this case since the return date in January 2018. And we say, for obvious reasons, the arguments that are raised now are not ones which were available to Grand Valley at that time. But I'll come on to that in more detail. I noticed that Mr. Liddell has something.
Apologies for interrupting Mr. Doherty, but it occurs to me there is one provisional housekeeping point we need to deal with, which is the issue of confidentiality and whether the hearing's in private or public before Mr. Doherty makes his submissions. Your Honour, you will have seen from my skeleton and from some correspondence that it's Sunteck's position that given this application refers to material in underlying arbitrations brought both by my client and Mr. Doherty's client, and the obligations of confidentiality under the LCI rules of Article 30.1, that the hearing should be in private. I understand that Mr. Doherty's client is not concerned about that on the basis that this matter has already been aired in open court. But Your Honour, the distinction is, of course, is that in this hearing today, you will be hearing more detailed submissions and evidence relating to those arbitrations. Your Honour, I can address you further. I've adduced one case in relation to obviously a principle you'll be very familiar with, which is the principle of open justice. And I can draw your attention to that and the RDC 35.47, where we say it would be in the interest of justice. Your Honour, I'm in your hands how you want to proceed with that, and whether you have any indications you want to give at the outset.
Well, I can't think that there is a huge public interest in this case. Matters have been dealt with in open court before. I'm perfectly prepared, if necessary, for any judgment to be anonymised, but that would seem to me probably the most sensible and practical course to continue with this as an open hearing and for judgment to be in an anonymised form. Would that satisfy the parties?
Your Honour, yes, I think subject to this point, which is one of the key concerns, that we are not faced down the line in any other forum or in this forum an argument by Grand Valley that we are in breach of our confidentiality obligations. It would obviously be a very unattractive argument in circumstances where Grand Valley are not seeking to have this hearing in private. But to allay our concerns, if that confirmation is provided, I suspect that the issue of whether this hearing is in private or public would go away.
Well, I don't know if Mr. Dock is in a position to give that confirmation, but it seems to me blindingly obvious that there's no basis upon which any allegation of breach of confidentiality could be raised when they wish to have this hearing in open court. Do you have any instructions, Mr. Doherty?
I don't have instructions yet. I'll obtain them. It's not entirely clear where the objection comes from. I don't think that there's ever been any intimation of Grand Valley seeking to take a point about that. Like Your Honour says, it's blindingly obvious. In relation to the general approach to the proceedings, you may have noted already that our position is that there is no good reason why these should not proceed in public. They proceed in public up to now. The judgment following the return date is available online. In fact, I think it's cited in the Green Book. But it's beyond that. There are other sets of proceedings related to this, also in the DIFC courts, including CFI Case 44 2018,
Yes.
which I think has hearings available on the DIFC courts YouTube channel. And in both sets of proceedings, issues relating to the underlying joint venture agreement, issues in the arbitration have been vented. And really, there doesn't seem to be a clear reason why at this point there should be a departure from that course.
Yes. Well, I'm inclined simply to hear this matter in open court, and if you want to make any further submissions and you've got further instructions, all well and good. I can't, for the moment, see why it's necessary to delve into matters that are being dealt with in the arbitration in any great detail in any event. You can take it that I've read not only the submissions but the witness statements. I've looked at the list of issues in the arbitration, and I'm sufficiently familiar with what's going on. So I think we can, for the moment, proceed in public, and we'll see where we get to with regard to anonymisation of any judgment if needed. Yes, all right. Well, let's continue on that basis. Mr. Doherty, it seems to me that the first point you have to deal with is the point of delay. You say there's been delay on the part of the claimant in not doing anything in this jurisdiction. But the question arises, why is it that you're taking this point at this stage in relation to the escrow agreement and the construction of the escrow agreement, when that was a point that could have been taken way back in November 2017? The arguments that you raise now, essentially, are all arguments that were open to you at the time.
Yes, Your Honour, I think I would characterise that somewhat differently. The issue in this instance is that what appears to have been contemplated by everyone who's involved in this back in 2017 was that there would be some relevant substantive proceedings that were to be brought in due course by Sunteck, and those were referred to, I think, in a number of different documents at the time and correspondence at the time. Effectively, what it was saying was, here are the grounds on which the DIFC court has jurisdiction. We will be bringing a claim in relation to the release of the documents or for other relevant declaratory relief in due course, either in the DIFC courts or by way of LCIA arbitration.
Yeah.
What is now known, which wasn't known then, is that Sunteck weren't going to be bringing a claim for any relevant relief in light of the basis upon which the injunction was granted. And there are a number of different reasons we say that it's taken up until relatively recently for that to become clear. One of those reasons is the history of the arbitral proceedings themselves, which is that the pleadings in that case didn't effectively close out until late on in 2020. I think it was in September 2020 when the last effective round of pleadings was submitted. That was a particulars of quantum in which Sunteck set out its statement of relief that it was seeking, and in particular what it was seeking by way of damages. And of course, it's a short hop from there to when we had the final merits hearing, at which point it's obviously become clear precisely what the scope of the relief sought by Sunteck was. And it also became clear that at that point, obviously, they couldn't seek to amend that statement of relief to try and put in some claim for, say, a permanent injunction or some kind of declaration which might have had some bearing on the injunction that was granted. So the material...
Sorry, you finish, Mr. Doherty, and then I'll ask a further question.
Yeah, so our broader point is in effect that the material change of circumstances has arisen because it's only once proceedings have plodded out and the premise of the way in which Sunteck has decided to proceed with its claim have become known that Grand Valley could ever have been in a position to take a point, for example, that damages were an adequate remedy, because now we know exactly what is being claimed, or, for example, that there had been a failure to prosecute a relevant substantive claim such that there would be a serious issue to be tried.
Yeah, the problem is this, Mr. Doherty. I don't think you were involved at the early stages, but it was apparent to the court from the earliest days that there was, and I think it's pretty clear when you stop to think about it, that if the escrow agreement is on its face of it subject to the jurisdiction of the DIFC court, a point which I decided early on, but the joint venture agreement is subject to the arbitration, that there is inevitably a problem as to how the two are to be dealt with. At no point was it ever suggested that absent agreement between the parties, the joint venture material could be dealt with in the DIFC or the escrow agreement material dealt with in the arbitration. So they were inevitably going to be two separate jurisdictions with linked issues. And self-evidently, the question would then arise, well, how do you deal with that? And in the skeletons for the first hearing, or at least the return date, if not the ex parte hearing, it was always contemplated that there would be a resolution of the underlying dispute in arbitration unless the parties agreed differently to have it heard in the DIFC. And in those circumstances, as the claimants put it, the anterior questions would arise in the arbitration as to the validity of the notice and the funding obligations of the parties and so on. And any question about the escrow agreement itself would be stayed effectively until that matter had been heard. And the logic of that seemed to me to be inexorable and is increased, if anything, by the fact that you're within sight, at least, of an arbitration award, however long the arbitrators take in their deliberations. And that's the sort of fundamental underlying question that appears to me you'll have to deal with. In a sense, the delay is worse for you because the arbitration award is in sight, so to speak, now, where it wasn't back in November 2017. The point has always been open to you to make that the terms of the escrow agreement mean that you can't look at the validity of the notice of default and so on. And that again has always been a possibility and was not an argument that was taken on the return date at all.
Yes, Ron, I think there are a couple of issues that arise from that. One is that the position that this case is in now, we say, is such that notwithstanding that a final award may be rendered in reasonably short order towards the end of the year, the point is that whatever the outcome of the arbitration proceedings, it's not going to have any bearing on matters to be decided under the terms of the escrow agreement, and the interim injunction is going to have no bearing on what ultimately Sunteck will or will not get out of that. So if the injunction was to fall away, it's not going to have any bearing at all on Sunteck's rights, which is pursuing an action in arbitration. Perhaps the easiest way to take Your Honour through that is to go through the submissions we have on what the escrow agreement actually sets out and how these proceedings have developed.
I think I understand that argument perfectly well, Mr. Doherty. If I may say so, the argument is in one sense relatively clear, isn't it, as to what the terms of the escrow agreement are, which don't entitle the escrow agent to investigate a whole range of matters. He's tied by the agreement, and that was the very reason the injunction was sought, because on the face of it, he was tied by the agreement. Although there was quite a lot of material suggesting that evidence had been put before him, which he was ignoring, the point was always open to be taken that he wasn't entitled to look at any questions relating to the validity of the notice. That's what clauses 4 and 5 were about. They were tying his hands. And the oddity about that, which was plain to me at the time, is that what happens then in relation to the anterior questions as to whether there is entitlement to give a notice and whether there has been a breach. And to be frank, if someone had come along and raised the matters that you are raising now, the argument would have been, should the DIFC court stay its proceedings to wait the arbitration result, or do the terms of the escrow agreement militate against that in such a way that it's not right for the court to do that? Because the argument would have been open to you to say, well, look, this is what the escrow agreement says. The parties agreed on that basis. The court shouldn't interfere. And the documents should be released to your clients, regardless of whether at the end of the day they're right or wrong in the arbitration matters. And if Mr. Punwell, I think it was, who was appearing at the time, had raised that argument, I'd have had to deal with it. But we're three and a half years under the bridge since then.
Yes, Your Honour, it's safe to say that had the argument been raised at the time, the response to that argument from Sunteck would have been, well, these are, of course, issues to be tried. The jurisdiction of the court here is not to conduct a mini trial, but to decide the much lower threshold. And what they will have said is that we will be bringing a claim for relevant relief in due course, for which we seek an interim injunction in the meantime. The reason that these arguments are being canvassed now is because we say that hasn't happened. We say that there is no serious question to be tried, which formed the premise of the court's granting of the injunction, because we can see in the clear light of day how Sunteck has decided to put its case in the arbitration. We've seen the list of issues, we've seen the statement of relief sought, and we can see that the outcome of those proceedings are going to have no bearing, which is binding on amongst other parties, Tamimi, who aren't a party to the joint venture agreement, it's going to have no effect on how this court would subsequently seek to interpret the escrow agreement. It's going to have no impact on the recoverability of losses claimed by Sunteck in the LCIA arbitration, which is why we make the point we do about the adequacy of damages. And in short, what it means is that the outcome of the LCIA arbitration is largely immaterial to what ought to have been the serious question to be tried, which is a serious question under the terms of the escrow agreement. So what we say is that what's effectively happened is that Sunteck have sought an interim injunction by applying the usual legal principles in obtaining that sort of relief on one premise, which is that there's a serious question to be tried under the terms of the escrow agreement, and that damages will not be an adequate remedy for that. And at the time, they represented that there would be some form of claim to that effect. And for example, Your Honour will find that I've set these out at paragraph 42 of my skeleton, but a couple of them, Sunteck's Part 8 claim form, which is at B, tab B, or bundle B, tab 1, page 2 for your reference. Says that the application was made on an interim basis, pending a final decision as to whether the first defendant is required to retain documents or may release them to the second defendant. And that's the final sentence of paragraph 7 on that page.
Yeah.
So the point there is that Sunteck acknowledges that in order to sustain an interim injunction, it needs to seek some form of relevant substantive relief relating to the terms of the escrow agreement. And that's acknowledged again elsewhere. So this time at H1, page 19.
Is it your submission that whatever happens in the arbitration, if, for example, everything is decided against the second defendant in the arbitration, that you're still entitled to come to this court and obtain release of the share certificates under the escrow agreement?
I think our point I put slightly differently, which is that one doesn't have a direct bearing on the other, and the injunction.
That's what I'm
Yes.
interested in, Mr. Doherty. You say they don't have a direct bearing. There's plainly a link, so to speak. There's always was a connection between rights under the JVA and rights under the escrow agreement. Though they are separate agreements, they are in a sense about interconnected matters, obviously. I mean, that's what the joint venture was about, and the share certificates and 50-50 and so on and so forth. I'm interested to know whether you can say, can properly say, I suppose, that whatever happens in the arbitration, you're entitled under the terms of the escrow agreement to release of the documents.
Yes, and I can take Your Honour through that. You obviously are familiar with the provisions in clause 4 and clause 5 of the escrow agreement, but the point is that whilst the escrow agreement may be related to the joint venture agreement, the intention is that it operates independently of it, and we know that for a couple of different reasons. But for example, we have clause 4.4, which provides that Tamimi, whom it's important to remember, are only a party to the escrow agreement. Tamimi are not a party to any of the other agreements, to the joint venture or to the addendum. But they, on the express terms of clause 0.4, aren't required to investigate the performance or non-performance of the JV agreement, because of course that's something which is governed separately. There's an arbitration agreement in the joint venture and so on. So Tamimi's role is necessarily limited. They have to act strictly in accordance with the escrow agreement. That's clause 5.1.
Yes.
We have clause 9, which is, Your Honour will find, it's at page 104 of tab A for your reference, but there you'll find that there's an entire agreement clause.
Yes.
And of course, at clause 11, we have the separate jurisdictional provisions, which provide, on Your Honour's findings, that that sort of dispute subject to the DIFC court's jurisdiction rather than to arbitration. So again, we have a clear understanding that the escrow agreement is to operate in isolation of the connected underlying agreements. So it's a self-contained contract on its own terms.
Yes.
And Tamimi,
So is
in the context of that
is
agreement,
is the answer to my question yes, Mr. Doherty? You do say that whatever happens in the arbitration, you're entitled, under the terms of the escrow agreement, to release the document.
yes, that has to be correct, based on how the arbitration we know is premised, and the fact that it's not seeking any declaratory relief, for example, that has a bearing on the interpretation of the escrow agreement, or it's not seeking, as I say, injunctive relief or anything like that. That leaves us in a position where a long stop notice has been served. Tamimi have considered the long stop notice to have been valid. They have invited Sunteck to provide evidence within 7 days under the provisions of the escrow agreement. It confirmed that the letters received from Sunteck's then solicitors, Baker McKenzie, did not constitute evidence for that purpose, and the 7-day period of time then elapsed. And under the strict terms of the escrow agreement, the documents were to be released to Grand Valley. That is how that agreement operates.
I understand that.
It's intended to be contingent on what happens under the joint venture agreement. If Sunteck were to raise some dispute under the escrow agreement, it might have said, for example, that Tamimi are wrong about what does or does not constitute evidence, and there should be some ruling about that. As, for example, why the Baker McKenzie letters were sufficient and were provided within 7 days. They could have said that. They could have said, or they could have raised some argument about what the term contractor meant, or what the proper interpretation of clause 4 was in terms of meeting the requirements of the underlying agreement. But there's no declaratory relief in the arbitration proceedings on that point, and there's no other request that the tribunal needs to look at the escrow agreement and to make a decision regarding the escrow agreement. And so the outcome of those proceedings is not going to have any bearing on what happens under the escrow agreement, and the outcome of those proceedings, of course, is not going to be binding on Tamimi. So the point there is that what Sunteck has sought to do in obtaining the injunction in the first place is to invoke the jurisdiction of the DIFC court to restrain Tamimi as a registered DIFC entity from acting in a particular way on the basis that there was a serious question to be tried under the terms of the escrow agreement, which again is subject to the DIFC court's jurisdiction. And what we say is that that's a distinct proposition from seeking an interim injunction against Tamimi where the underlying dispute relates solely to the joint venture agreement, which of course is governed by the arbitration agreement, and where the escrow agreement on its own terms says that Tamimi is not tasked with resolving disputes for non-performance or for breach of the joint venture agreement. So we need to be clear, I think, in maintaining that distinction.
I'm going to tax you again, Mr. Dockery. I'm sorry to keep being
That's quite all right.
And it's an advocate's misfortune that the judge can keep asking the same question time and time again. But let's take the long stop date as an example. The long stop date is defined in the escrow agreement as the date upon which Grand Valley issues notice to the escrow agent of a default. Right? And on your construction of the escrow agreement, the escrow agent is not entitled to look behind that notice. If it's on its face a conforming document, that's good enough. So he never inquires as to whether or not there's been has actually been a default.
Yes.
Yes, go on, let me just finish, and then you could have your say again, Mr. But if the arbitrators decide that there has been no default, there has been no contractor appointed, there has been no valid notice of default, and therefore no long stop date, what happens then? Would you still be entitled to come to this court under the escrow agreement and say, well, never mind, the arbitrators decided all that. The escrow agreement operates so independently that you must ignore all that and make the escrow agent release the document? I mean, that is the quandary that I was grappling with back in 2017, as I remember it. What is one meant to do? And the idea that you could make an order at that stage that there be a release of documents when you knew that the arbitrators had found, as between the other parties to the JVA, that it was invalid, sticks in the craw. And whilst I take your point that nobody was talking specifically about this being an injunction in support of the arbitration, and I understand your arguments on Article 24 and so on and so forth, you know, no one was taking the point that that was a problem. The question was one of justice. What does it make sense to do in the circumstances? And I'm rather inclined to think that if the sort of point that you are taking now had been taken at any stage in the last 2 or 3 years, my inclination would have been to say, well, I'm just going to stay the proceedings in the DIFC until we see what the arbitrators decide. And I think it has to be your submission that that would be an entirely wrong thing to do.
Yes, Your Honour, that is precisely what we say. The underlying reason that the injunction was granted at the time, and I'll read this from, this is the skeleton argument for Sunteck for the return date.
Yeah, let me just look at, oh, yes, okay, I think I've printed that off, actually. Yeah.
So it's Bundle H, tab 1, page 19, but...
Yes, no, thank you. Wait while I just get there. Thank you.
Quite all right.
What I've done, Mr. Doherty, is I've printed off some of the key documents and I've got the rest on screen electronically. But I want to refer to them as you go, so don't be afraid to wait while I get there. Page 19, did you say?
Yes.
Yeah, and which paragraph?
So it's beginning SL may seek.
Yes, got you.
So what they're saying here is SL may seek two options. One, to show by way of action the DIFC courts that it's entitled to release to Sunteck the documents under the escrow agreement, or the Grand Valley is not entitled to delivery. Or two, to establish by way of LCA arbitration that there's been no valid appointment of a contractor or such other relevant facts as may be declared under that agreement. The point there is that there's an acknowledgement that in order to sustain the injunction, there has to be a set of proceedings which are raising a request for relevant relief. And when I say relevant relief, what I mean is relief that is relevant and connected to the basis upon which the injunction has been granted.
Yes.
Now, Your Honour, you have looked at the list of issues and at the statement of relief. And what we say about that is that notwithstanding the amount of time that has now elapsed and the amount of time that Sunteck was given to formulate its claim, what you won't find, obviously, is any claim before the DIFC courts in relation to the escrow agreement. But when it comes to the arbitration, there is no claim seeking a declaration as to the interpretation of a term. So, for example, what does it mean for the appointment of a contractor? I mean, there's a separate question about whether that's relevant at all anyway, because contractor is its own defined term within the scope of the escrow agreement itself. And as we know, Tamimi aren't required to look at the joint venture agreement in determining how they act. But there isn't even a claim for some relevant declaratory relief within the scope of those arbitration proceedings, which is going to have a bearing on the court's decision about what it should do with the injunction. That is the sort of claim that Sunteck may well have brought, and clearly that's the sort of claim that it had envisaged at the time the injunction was granted it would be bringing. That's what it said in its skeleton argument. As I say, at paragraph 42 of my skeleton, I've set out a number of different exchanges and sets of correspondence in which the same thing has been intimated, which is there is going to be some relevant claim. And we say that it is inherent in the court's exercise of its discretion under the American cyanamide principles that there has to be a connected underlying set of proceedings for some substantive relief, which is relevant to the court's decision to grant the injunction. And we say that that's completely absent in this case. So really what ought to have happened is that when the parties turned up to the return date and Sunteck said, we have a claim, and they set out in their skeleton argument, here's what the claim is, it was then incumbent on Sunteck to actually pursue a claim for that type of relief. And what we say about that, and again, this comes back to the distinction between a claim which is premised on the escrow agreement and a claim which is premised on the joint venture agreement, is that it's not sufficient for Sunteck to have simply brought ancillary proceedings for some form of relief in the LCIA arbitration. And
well,
there are a couple.
If we look at paragraph 13.1, isn't that being pretty straightforward with the court? The paragraph you've just directed my attention to, saying either we'll do this in the DIFC court or we'll establish in the LCI arbitration that the underlying events which are said to give rise to the notice of default and the long stop date simply don't hold good.
No, we say it's saying something slightly different from that, which is for the court to be satisfied that there is a serious question to be tried, it's not simply asking whether there is some triable issue between some of the parties in some jurisdiction.
Yeah.
If one looks at Lord Diplock's judgment in American Cyanamide, it's pretty clear, and I think I've referred to it in my skeleton, that the principle is that you grant an interim injunction on the basis that the party will then go on to seek a permanent injunctive relief or some relevant declaratory relief. For example, which will then be resolved at trial. So there has to be a connection between the basis for the granting of the interim relief and what the outcome of the substantive proceedings is going to be. They can't just be, you can't just say there is a serious issue to be tried, even if it's wholly disconnected from the purposes for which you're seeking the injunction in the first place. What we have here are arbitral proceedings in which Sunteck are seeking effectively damages for loss of profit. They're not, for example, seeking any kind of proprietary claim over the land. They haven't sought any declaratory relief in respect of its shareholding under the terms of the joint venture agreement. It hasn't sought any specific declaratory relief in respect of the interpretation of particular terms of the joint venture agreement, which means that all we have are arbitral proceedings seated in a foreign jurisdiction, which Sunteck is now seeking to use in order to maintain an interim injunction that was granted on a completely different premise, which is that it had a substantive claim under the escrow agreement for which the DIFC court had jurisdiction, one, because Tamimi was a DIFC registered entity, but two, because it had a jurisdiction clause in favour of the DIFC in the first place. If, when the interim injunction was granted in the first place, Sunteck had turned up to the court and said, we are going to bring a claim in damages in an LCI arbitration seated in Singapore, what one might have asked is, well, what's the premise for bringing that sort of application before this court, where we have LCI proceedings which are seated in a foreign jurisdiction? The normal course would have been to bring an application under Article 24 of the arbitration law, but Sunteck, of course, knows full well that it can't bring that sort of application because the arbitration would have needed to be DIFC seated for that to work. What's effectively happened is that Sunteck have sought to get around those provisions in the Arbitration Act by alluding to the existence of some claim under the escrow agreement with the DIFC court's also jurisdiction, despite the fact that it's shown no actual intention of seeking any substantive relief in connection with that agreement. So put differently, what we say is you can't make the application on one premise and then seek to maintain the injunction afterwards on another incompatible premise, where if Sunteck had presented its case that way in the first place, the DIFC court may have taken a different view on its jurisdiction to grant interim relief at all. And I suppose the second connected point to that is that even if one were to accept that it was conceptually possible for Sunteck to have sought to get an interim injunction in support of foreign arbitral proceedings, that is, proceedings under the JVA, it still hasn't sought relief that is relevant to the underlying purpose of the injunction. So the purpose of the injunction is to effectively hold the ring. We have a potentially valuable shareholding on Sunteck's case, which needs to be maintained until the proceedings are dealt with. But for reasons I've already taken your honour to, that's not what has happened. It's a claim in damages. In fact, part of the claim in the arbitration seeks to wind up the joint venture company and to terminate the joint venture agreement. So one can quite reasonably ask, what residual value is there in maintaining the injunction anyway? Clearly, on Sunteck's own case, what will happen at the end of the arbitral proceedings is it will either get damages or it won't.
And if it does get damages, and therefore its claim is satisfied, if the matter then came back to the court, you say it's inevitable that the shareholding would be, share certificates would be released to you.
Yes. So the point is that
the share certificates and the shareholding in the joint venture, which owns valuable land, is effectively operating as some form of security for any damages that might be awarded. That's the reality of the current position, is it?
Well, no, I'm not sure that that's necessarily the case, because it's it's
I'm
held
not
by a
saying
third
that-
party to the escrow agreement, the joint venture company.
I know, I understand that, but that's the effect of it, isn't it? Whether they're entitled to it is another question. But that is the effect. Your case, as I understand it, is very straightforward. You say you simply look at the escrow agreement, and you're not entitled to investigate any of the matters the arbitrators are investigating, and therefore, end of point, the court should discharge the injunction so that Tamimi can do what they're obliged to do under the escrow agreement. And I've always understood that as a possibility, but it's a point that's never been taken before in 3.5 years.
Yeah, sure, but I hate to sort of stress the same point again, but I think that the reason for that, just to be very clear, is that
Well, I don't accept
that.
That can't be right. It's always been pretty clear that what would be happening in the arbitration would not be seeking relief under the escrow agreement because of the jurisdiction point. The escrow agreement was subject, as this court has found, to its own jurisdiction, whereas the arbitration was subject to the arbitrator's jurisdiction. So there was always going to be a separation of issues, albeit that they were ultimately connected, to use that expression in the looser sense of the word.
Yeah, so what we would say is that the point, which is now clear, is that the outcome of one is not going to have a material bearing on the other, and that wasn't necessarily always going to have been the case for some of the reasons Your Honour has already vented, which is what is the connection between the underlying obligations or the appointment of a contractor, and so on and so forth. Had there been in the arbitration proceedings a request for a declaration as to the proper construction of a particular term of that agreement, which has a like term in the escrow agreement, one could quite reasonably see that there might be an argument in favour of maintaining an injunction over the escrow agreement until you resolve the other proceedings. But our point is that that is not how this claim has been proceeded with, and that's why, after all this time, it is now very clear that there's no serious issue to be tried under the terms of the escrow agreement.
But can you tell me how there could ever have been in the arbitration anything which was directly relevant to the terms of the escrow agreement? It's always that which antecedes the operation of the escrow agreement that is going to be the subject of the arbitration. I mean, the very points we've just discussed: was there a contractor appointed, who was obliged to provide funding and when, did the long stop date pass, and so on and so forth. These are all matters which could be decided in the arbitration, and even without express relief being sought in relation to them, may still be decided in the arbitration. The funding is bound to be decided in the arbitration, isn't it? Was there a breach in failing to provide funding, and so on and so forth?
Yes, although that, of course, is not going to have any direct or binding bearing on what Tamimi needs to do under the escrow agreement. But one example of where there may have been crossover, but no claim has been sort of premised on that basis, is under the Addendum Agreement, which is the agreement which sets out what the purpose of the escrow agreement is to be and how it's intended to operate.
Well, can you
So
show me
it's more, it's, yes, of course, it's Bundle A, tab 2.
Yeah.
And it's clauses 4 and 6, which deal with share transfer and the share escrow mechanism.
Yes. Let me just look at that. Yeah.
So if one looks in that, one could see a world, for example, in which Sunteck say, we are entitled to receipt of our share certificates under clause 6, or a declaration that Grand Valley are not entitled to it under clause 6. But again, we don't have, and one could see how conceptually that might have some bearing on the court having granted an injunction in this case. But for reasons I've already given, that's not how the case has been premised.
Yeah. Yes. All right. Well, I've asked plenty of questions, Mr. Doherty. I'm taken you out of your course, no doubt, but please feel free to pursue the arguments in any way you wish from here on, and I'll try to keep quiet.
Yes, Your Honour. Let me just look back to my note. I think probably what we've discussed is quite a number of the submissions that I have in relation to whether or not there's a serious question to be tried and whether that's a proper basis for the injunction to be discharged at this stage. I suppose I'll give the headlines to recap what those are before moving on to the other submissions.
Yes.
The first point is one I've already mentioned, which is the position under Article 24 of the DIFC arbitration law. Is just to say that I don't think that there's actually any dispute between Mr. Liddell and I about the scope of the court's power there. I think he agrees with me that the application wasn't premised on the DIFC arbitration law, and I think he also agrees with me that Sunteck couldn't have made that sort of application anyway based on deer and waterfront property investment, which he also refers to in his skeleton. We say that it has to follow from that Sunteck must agree that the LCIA arbitration proceedings fall to be characterised as foreign arbitral proceedings, and so Sunteck couldn't have sought an interim injunction on that basis. That then, as I say, raises the question of what the serious issue to be tried is, and I refer in my skeleton to what the proper understanding of the American cyanamide principles are, which presuppose that there has to be some substantive action which is actually connected to the basis on which the injunction was granted. And on that point, Your Honour will note, I've referred in my skeleton to the premise of your earlier findings on jurisdiction. That is that the court has jurisdiction to grant an interim injunction, one, because Tamimi was a DIFC entity, and I think it was also under A1C on the basis that the escrow agreement was wholly or partly performed in the DIFC. And the second was on the basis of clause 11 of the escrow agreement, which conferred jurisdiction on the DIFC courts.
Yes.
And just for your note, by reminder, that's paragraphs 2, 17 and 25 of your earlier judgment.
Yes.
And what we say is that none of those findings would actually apply if the only underlying case was under the joint venture agreement, because we don't have Tamimi as the jurisdictional hook, and we don't have the the clause. So unless we have some substantive dispute under the escrow agreement, the first test, or the first part of the threshold in American cyanamide is not overcome, because there can't be a serious question to be tried if it's only under the joint venture agreement. And as we say, that is in practice what's happened. Sunteck has not brought a claim before the DIFC courts. It's not brought a claim under the terms of the escrow agreement. In the list of issues for the arbitration, there is no reference to the escrow agreement or to any of its terms, or indeed to any relevant connected terms within the joint venture agreement or the addendum agreement. Nor, for that matter, is there a claim for any relevant relief under the terms of the escrow agreement, or which could even have an impact on what could subsequently be claimed under the escrow agreement. So that's our point, that whichever way you look at this case, and whatever the outcome of the arbitration proceedings is, the court would have no proper grounds to continue the injunction. So if it's going to fall away, come what may, there's no reason to maintain the injunction now, is the point we make about that. So we say that on that basis, there can't be a serious question to be tried, and that is sufficient grounds for discharge. And of course, Your Honour has taken me through my submissions as to why we say that those are not points that could have been taken earlier, and why it was necessary to see how Sunteck was putting its case in the arbitration to know whether or not that could apply. So that's, as I say, a recap on serious question to be tried. Your Honour, there's the second broader point, which I think to some extent overtakes our prior discussion anyway, which is the question of whether or not damages are an adequate remedy. And as I say, I can deal with that in reasonably short order, in part because Your Honour has already looked at the statement of relief sought by Sunteck in the LCI arbitration. And importantly, for the purposes of this submission, the relief it's looking for is certain declaratory relief relating to the joint venture agreement. It's seeking an order terminating the joint venture agreement and potentially winding up the joint venture company. And then the principal relief sought is, of course, damages. It's on two bases, either for loss of profit or for a refund of some tax contributions under the JVA. And again, whatever way you look at it, if Sunteck gets its contributions back under the JVA, or if it gets its loss of profit, it doesn't claim or purport to claim any residual rights with respect to either its shareholding or to the land.
Yes.
So what we say about that is that even if one was to start with the assumption that there was a serious question to be tried, the way that Sunteck has put its case in the LCA arbitration is fatal to its seeking to maintain the injunction. And, Your Honour, if I can refer you just to a couple of extracts from American Cyanamide. I know it's well known, but it's really to underline some of these points. That's bundle I, tab 1. And the first extract I'm looking at is page 11.
Yes.
So first of all, at E, or just, I think it's the line above E, it says the object of the interlocutory injunction is to protect the plaintiff against injury by violation of his right, for which he could not be adequately compensated in damages recoverable in the action if the uncertainty resolves in his favour at trial. Then it goes on to say that needs to be weighed against.
Sorry, Mr. Doherty. Which page are you looking at?
This is page 11 of Bundle I, tab 1. Of the judgment, it's page 406.
Thank you. That's what I was looking for, the judgment.
Yes, sorry about that. And it's at E in the margins.
Yeah.
And then it goes on to say that that's to be weighed against the need for the defendant to be protected against injury from them having been prevented from exercising their own rights, for which they cannot be adequately compensated in damages. So in other words, the decision to grant an injunction is always a balancing exercise, but the point in American Cyanamid is that we only actually get there to conduct that balancing exercise if the court is satisfied that the applicant wouldn't be adequately compensated in damages.
Yeah.
And if we go on to 408A, and forgive me, of course, these are well-known principles, but 408 A, sorry, no, I think it's B, it's the first main paragraph, is where that is described as being the governing principle. So it's first the court considers if the plaintiff were to succeed at trial in establishing his right to a permanent injunction, he would be adequately compensated by an award in damages. And then it says if damages in the measure recoverable at common law would be an adequate remedy and the defendant would be in a financial position to pay them, no interlocutory injunction should normally be granted, however strong the plaintiff's claim appeared to be at that stage. And then it goes on to make the similar point again about the converse of that and the need for the respondent to the application to equally be adequately protected. And then I've referred to it in my skeleton, I won't take you to it, but it's 408F makes the point that the balance of convenience test we only get to after we've assessed the adequacy of damages. Now, the point we make about that is that on that basis, on those principles, the injunction must be discharged because Sunteck must be taken to accept that not only are damages an adequate remedy, but they are in fact the principal remedy that we now know it is seeking in the LCI arbitration. And as I already explained to Your Honour, that position that on the arbitration and the pleadings, it was the particulars of quantum that was eventually provided by Sunteck, wasn't provided until September 2020. So as of September 2020, we know, as a matter of fact, what's being claimed in the arbitration proceedings, and that, in effect, it's damages. That is not something we say which was known back in October and November 2017, or could have been known in January 2018, because obviously the formulation of the arbitration proceedings continued for a long time after that, over 2 years after that, in fact. So if it wins, Sunteck gets compensation for its loss of profit. As I say, no proprietary claim, no claim for any kind of declaration in relation to the shareholding. And in fact, given that it's seeking to wind up the joint venture company, it's not as if it wins in the arbitral proceedings, there's going to be any substantial residual value in that shareholding anyway. So whatever way one looks at this, the interim injunction serves no practical purpose, and certainly not one that would not be adequately compensated in damages if Sunteck is ultimately successful in the LCIA arbitration. And of course, on the counterfactual, if Sunteck loses, there would be no proper basis for the injunction to remain in place anyway. So it has to be the case that damages are adequate. Otherwise, Sunteck would have sought something else. And on the American Cyanamid principles, if damages are adequate, that's as far as the court needs to look, and the injunction shouldn't be granted. We can actually go a level beyond that as well, because adequacy of damages, as I've taken Your Honour to, it's a two-way street. It's not only a question of whether damages are an adequate remedy for the applicant, which on this case, clearly, even on its best case, they are, but also whether they would be adequate for a respondent or for a defendant to proceedings. And on that, can I take your honour to Bundle F, tab 5, page 951.
Yes.
So there, fingers crossed, you should find an extract from a procedural order made by the tribunal. This is in relation to an application for security for costs made by Grand Valley against Sunteck, and the relevant extracts here are paragraph 4.8, first of all, which is, after having reviewed all of the evidence and hearing the parties at the hearing, the arbitral tribunal agrees with the respondent, so that's Grand Valley, that the claimant, Sunteck, is a loss-making local investment vehicle with no active trading business, no self-sufficient method of capital generation, negative reserves, no significant assets, and so on. There's no evidence available that the claimant has assets or reserves to meet any award of costs. And then it's over the page, paragraph 4.10, where it says, on all of the evidence, the arbitral tribunal finds there's a serious risk for the respondent will not be able to enforce a costs award in its favour because the claimant will not have the funds to pay costs awarded. And the claimant itself does not have assets readily available for an effective enforcement of a costs award.
Yeah.
So we say that's about as clear a statement as one could expect to get, that the undertaking in damages provided by Sunteck in order to get the injunction is pretty hollow, and it's also highly material, not only to the court's consideration of whether, as I say, damages are an adequate remedy for Sunteck, which they are, but whether on the counterfactual an undertaking would adequately protect Grand Valley, which clearly the arbitral tribunal have already concluded it cannot. And so we say that on that basis alone, even putting to one side the submissions I've made on whether or not there's a serious question to be tried, there is not a proper basis for maintaining the interim injunction. And that's because the second part of Lord Diplock's test as to whether damages would be an adequate remedy has to be answered affirmatively, and that's the end of the question.
I'm sorry, I'm being rather dense here, Mr. Doherty. How does the question of the inadequacy of the undertaking in damages really impact on this here?
No, I should say that it's 2 points really. It's the question of adequacy of damages, first of all, requires the court to ask, are damages adequate?
I've got that.
For the claimant, yes. In this case, it's that American Standard points out that it also cuts both ways. If damages are not adequate to protect a defendant to proceedings, that weighs in favour of not granting an injunction. And so the point here is that we already have a finding by the tribunal that Sunteck has no assets, and there's a high risk that it wouldn't be able to enforce, that Grand Valley wouldn't be able to enforce a costs award, and so it granted security for costs. And so that's relevant to whether or not the undertaking in damages is adequate. Your Honour, then have a few short additional points on the balance of convenience. Obviously, on our primary case, we don't get there, but what we say is that, again, even putting aside the submissions we've already made, the balance of convenience has shifted somewhat considerably since the injunction order was made. First of all, you may have noted in my skeleton, there's a reference to the suggestion, I think it was in the ex parte hearing back in 2017, that the only prejudice Grand Valley would suffer were minor delays to enforcing its right under the escrow agreement. Of course, that has been shown to be wrong, as a matter of fact, given that we're now coming up on 4 years since the injunction was put in place without, we say, any substantive proceedings being brought by Sunteck under the terms of the escrow agreement. The second point, I think, is potentially more consequential, which is that the current situation is the joint venture company is being completely hamstrung as a consequence of the ongoing protracted issues between the parties, the effect of which means that it doesn't have an effective board, and it's being placed in what we say is an extremely vulnerable position of having substantial debts exceeding 60 million dirham without any recourse to actually paying those debts. And of course, that doesn't just place the joint venture company itself at risk, but it places the land, which holds a substantial value that was transferred to the joint venture company by Grand Valley, at risk. And Your Honour may be familiar, for example, with the sorts of provisions you get in sale and purchase agreements for master developments, which say if you don't pay particular fees, what rights of action master developers might have against you. The point there is that unless something is done, if everything remains tied up, there is a risk to the joint venture company and the land effectively being alienated. We also say that Grand Valley are pursuing separate arbitral proceedings, but until those are resolved, which is obviously going to take some time, it needs to take steps to try and mitigate its losses. And the interim injunction is something which is standing in the way of it realising any kind of profit or limiting any of its losses in relation to the development of the land, which is, as I say, just sitting there accruing debt. By contrast to that, and I say this ties into some of the previous submissions I've made, Sunteck will suffer very little substantial prejudice at all if the order is discharged. As I say, it's not prosecuting any active claim against either Grand Valley or Tamimi under the escrow agreement, and the discharge of the injunction order is not going to have any bearing on its ability to claim damages from Grand Valley in the LCA arbitration, where the final award is pending. So if the order is discharged, they'll be in the same position as they were before to seek to claim damages and to try and enforce award of damages. And so all of that, we say, means that the balance of convenience has shifted considerably towards discharging the injunction. And Sunteck's position that the court should continue to hold the ring is undercut, not only by that, but for reasons which I've already explained, because in our submission there is no longer a ring to hold. There's no dispute, and so there's nothing to preserve pending the outcome of the arbitral proceedings.
What's the effect of discharging the injunction if Tamimi then release the share certificates to Grand Valley? The arbitration is still continuing. There are still issues under the joint venture. Do you say that if the share certificates are released, you can then simply change the composition of the board and take decisions about development of the land held by the joint venture company, notwithstanding the fact that arbitration proceedings are pending and so on and so forth?
Well, yes, well, I suppose there are a couple of points built into that. There's one, yes, which is the intent to try and mitigate Grand Valley's losses by taking some substantive actions on behalf of the joint venture company to try and realise something from what has been an unfortunate history to this joint venture. I suppose the second.
Can you do that? Is really what I'm asking. You know, the stalemate arises because the joint venture agreement provides that there should be 2 directors from each party and so on and so forth, and therefore any future progress is stymied, isn't it? But just because you have share certificates released to you by Tamimi, does that solve your problem and enable you to take action to, quote, mitigate your losses?
I think in our case it would, but I suppose perhaps the more important point is that that is, we say, the inevitable consequence of either outcome from the arbitration proceedings. So if Sunteck succeed in full and they manage to claim the entirety of their loss of profit, so what they would have gained out of the project had the land been developed and sold, they obviously would accept that if they're getting damages on that basis, they don't hold any residual title to the land which can then be sold, or residual rights in the joint venture company, because it's been compensated for its loss in the project and it moves on. The other way of looking at it is if it succeeds on its alternative basis of damages, it would be getting back the contributions that it made. And of course, under the escrow agreement and under the various other agreements, its rights in the joint venture company are proportionate to the amount that it's putting in. So if you're getting the money back, you similarly can't expect to have continued rights in the land or in the joint venture company, because effectively your buy-in is being returned to you.
Well, I understand all that, but that's premised on what the arbitrators decide. But before we get to that point, and after all, you're seeking discharge now, are you actually able, prior to the arbitrator's decision, to do anything practical in terms of the joint venture company and the land? That's my question. Doesn't it all, in fact, depend upon what the arbitrators decide?
Well, I think in my submission, we would say it doesn't, because it's not an issue that's currently before the tribunal.
No.
It may well be that there's an issue about that between the parties.
Isn't there an issue before the tribunal as to whether the company ought to be wound up?
Yes, on Sunteck's case, yes, there is.
Yes. And if you sought suddenly to do something with the company and its assets, you'll immediately be met with an application to the tribunal to stop you from doing that, won't you?
Perhaps not. The point is that that's a matter
not
for
me to anticipate. You say, yeah. I'm just trying to see what the practical effect will be. When it comes to mitigation of losses, no one can say you've behaved unreasonably if you can't do anything with the company because this injunction exists. Then, of course, you may ultimately have to a different claim in relation to the undertaking in damages, I suppose. But on the face of it, if you're shown to be right in the arbitration, then presumably you'll get damages in the arbitration, won't you?
Well, there are problems with that, which I've already taken your honour to in relation to
recoverability.
Sunteck's, recoverability of damages from Sunteck. But I suppose to frame it slightly differently as well, I don't think that either party would seek to suggest that an interim injunction should just remain in place indefinitely when there's no proper basis for sustaining it.
No.
And having made the submission that there is no proper basis for sustaining it, rather than saying, well, what practical effect will there be from discharging the injunction?
Right.
I think that the answer to that is,
well,
if there's no proper basis, should be discharged, and the pieces should fall where they may. But on any analysis, it can't just continue going on and on and on. And if
understood, but the reality is the balance of convenience and balance of prejudice argument may not take you very far. Your real case comes down to the fact that there's no basis upon which it should be continued, full stop. Never mind the balance of convenience and so on.
Yes, that is the primary way we put our case, although I would still stress that the balance of convenience is a balancing act, and whilst we do have some points in our favour, ultimately Sunteck doesn't, we say, have anything.
Yes, I've got that point. Yes. Now, is that just about it, Mr. Doherty?
I think so. As I say, everything else, if you want to go through it in any more detail than that, is in my skeleton. But I think I've managed to pick up all the points I'd intended to address Your Honour on in oral submissions. Hopefully I haven't missed anything.
Yes. I think there's only one more question I want to ask you at this stage, and you'll forgive me for asking something which is in part a repeat of what's gone before. What is the downside to you of waiting for the arbitration decision, whereupon it will be clear what has been decided and whether or not it has any impact in relation to the matters that the court here is concerned with? If the arbitrators decide in your client's favour, in essence, then there could be no question of this injunction being discharged. If they decide in favour of the claimant, your case still is that you are entitled to the injunction being discharged, and indeed to a release of the documents, which you assume ultimately would then deliver. The advantage of waiting is that there is then clarity as to what the parties' underlying rights are. And whether there has been a proper notice of default and so on and so forth. What's the real downside to you? I appreciate all you say about the points of principle and why this shouldn't really arise in your submission.
Yes.
But we are where we are because for 3.5 years, an injunction which you say was wrongly granted has been in existence without challenge, which is, as I see it, one of your major problems in coming to the court, given the discretionary element that the court has. So, is there anything you want to say about the downside of waiting just a little bit longer?
Well, I think, yes, Your Honour, a couple of things, and I suppose some are practical, some are potentially even more consequential than that. Obviously, the first point we would make is that we're going to have to come back before the court seeking the same thing again when there's no practical, there's nothing practical to be gained from continuing the injunction when there's no proper basis to do it. And coming back before the court and incurring the cost of doing that is obviously prejudice.
Yeah.
The additional point we would make is that, first of all, and I suppose it's a repeat of what we say about balance of convenience, but Grand Valley would be precluded from taking any practical steps or even attempting to take steps to try and better its position or to try and do something with the land and with the joint venture company. And I note Your Honour raises questions about whether the escrow agreement and the release of share certificates would allow them to do that anyway. But we would say that the proper course is not for the court to intervene in that without proper justification, but instead to permit parties to exercise their contractually agreed rights in the normal way. The additional points that it's not entirely clear how long one would expect to wait for a couple of reasons. First relates to the first arbitration, which is there will be an award at some point, one hopes, this year, but of course no one can be specific about timings of that sort of thing. But what is also contemplated in those proceedings is not only an award being delivered on certain aspects of the merits, but it's understood between the parties that there might well be residual issues that arise from that and further questions that the tribunal might have to deal with, for example, on quantum of damages, but potentially on other things too. So having that resolved this year is by no means a guarantee, and it's by no means a guarantee that if there's one part of the arbitral award that's been returned, but there are still residual questions, that Sunteck would consent to the injunction being discharged. The second, I suppose, associated point is that there are, of course, the second set of arbitral proceedings, and one can't preclude Sunteck making similar arguments there to say that there are still ongoing residual issues between the parties that need to be resolved before the court can discharge the injunction. And those proceedings are by no means close to rendering a final award, and those are going to continue for some time.
Remind me what the second arbitration's about.
So that is, there had initially been a counterclaim in the first set of arbitration proceedings, which was withdrawn and filed separately in another arbitration, which is currently, I think, subject to a jurisdictional challenge, which is being considered. So it's still reasonably early stages, but it considers some of the, it effectively considers the parties' positions under the joint venture agreement.
This is your counterclaim that you failed to put up deposit for or something, is that right?
Yes, I think that's my understanding of it. So that's the second set. As I say, they're at an early stage.
And what are you claiming in that?
I'm not sure that a full statement of relief has been prepared yet. I'm not sure I have that information, but it's, as it was originally put in the counterclaim, it was a claim for damages. So I suppose the point we make there is
failure to produce the funding which would have enabled the joint venture to proceed, basically, and
to proceed and succeed.
Yes. Okay. Yeah. Yeah. That's what I thought.
All
right.
So that we say is a delay of uncertain length of time, and as Your Honour rightly points out, our main submission is that we don't actually get to that stage anyway, because you only get to balance of convenience after you are already satisfied on the points about serious question to be tried and adequacy of damages. And so we say that going through those varying steps, you just don't get there.
Yes. All right. Anything else you want to say at this stage?
No, thank you, Your Honour.
Thank you very much, and forgive my constant interruption. Yes, Mr. Liddell.
Your Honour, it remains Sunteck's position that the application is without merit, and with respect to Mr. Doherty, lacks realism. And that is in a large part, Your Honour, caused by Mr. Doherty's hands, or the client's hands, being tied by what was said or wasn't said at the return date hearing back in November. And Your Honour, could I just remind you of two particular issues that were set out in the skeleton argument for Sunteck at that return date hearing? The reference I have, Your Honour, is at F666, but I think Mr. Doherty referred you to another document in bundle H, so I apologise, but I've got F666.
I don't have an F6. Anyway, it's your skeleton you're interested in.
Yes, it's the skeleton argument for the return date hearing. Yeah. Mr. Doherty referred you to paragraph 13.1.
Yes.
Where the court was informed by Mr. Reed, QC, that Sunteck may seek, and then you'll have read the options at 1, and then the alternative option at 2, which was to establish an arbitration, and I highlight the words, for example, there has been no valid appointment of a contractor under the JVA or such other relevant facts as may be declared under that agreement.
Yeah.
And Your Honour will recall that one of the key planks, as I set out in the skeleton for this hearing, the key planks of the dispute under the JVA is whether or not there was a breach of the JVA by Sunteck in relation to its funding obligations.
Yeah.
And particularly clause 5C. And I don't know whether you need to be reminded of the wording of that, but you were referred to it at the ex parte hearing and subsequently. The clause stated, it's 5.2C, that the second party shareholder loan should be contributed by the second party as follows. And the first instalment was a cash payment of 35 million dirham on or before the execution of the construction agreement, capital C and A, to the contractor, capital C, on behalf of JVCo.
Yes.
And as I set out in the skeleton, the definition of contractor under the JVA and also definition of contract under the escrow agreement is essentially the contractor appointed to develop the project.
Yes.
And in addition, what the skeleton set out, if you could go to paragraph 11.1 of the skeleton before you in November 17, it's internal page 15 of the skeleton.
Yes.
Under the heading balance of convenience, the court was also, it was submitted to the court that if the injunction is set aside so the documents may be released, but Sunteck shows that Tamimi should not have released the documents, then at little one, Sunteck will have forfeited all of its shares. And then at little three, Sunteck's remedies will be either to pursue Tamimi for breach of the escrow agreement, but subject to an argument as to the circularity of his action in view of Tamimi's right under clause 5.3 of the escrow agreement to indemnity, or to pursue Grand Valley. And I'll be returning to this in due course in the question of whether damages are an adequate remedy. But what Mr. Doherty does is he invites you to say, because Sunteck claimed compensation and damages in the arbitration, that means that damages are an adequate remedy. And I'll return to this in a moment, but we say that is not the case. And Your Honour, just to complete the background picture, can I remind you of paragraph 6 of your judgment in November, which you'll find at C12.
Yeah.
And Your Honour will recall that Grand Valley was given an opportunity to serve or file evidence in response and in advance of the return date hearing, but sought only to challenge the jurisdiction of this court. And your judgment, of course, at C10 deals with those jurisdictional issues. But if I could just ask you to look at paragraph 6
Yeah.
at C12, where the court recorded that beyond the question of jurisdiction, there is nothing for this court to decide, since it is clear and unchallenged that the claimant has a good, strong, bona fide case, and that the balance of convenience lies in holding the ring and the status quo and preventing the release of the documents held in escrow. And Your Honour is familiar with the principles and the authorities that both parties have adduced in relation to this hearing as to the need for a party seeking to vary or discharge the order to show a significant change in circumstances. And the question then for the court to decide is whether or not Mr. Doherty's arguments on behalf of his client, for example, damages are not an adequate remedy or there's no serious issue to be tried, are indeed matters that turn upon new, significant material change of circumstances. And in Sunteck's submission, they do not. And in fact, Grand Valley has already had a bite at the cherry in raising new arguments. And Your Honour will forgive me if I'm telling you something you already recall. But after the hearing in November 2017, there was correspondence from Grand Valley's former solicitors, that was Baker Botts, to the court. It's referred to in Ms Sheffield's witness statement. Can I take you to that email? It's at F554. Your Honour, would it help if I shared this document on screen rather than you?
No, I'll get there. It may just take me a bit of time. I'm on F370 at present. Where we go. 554.
554 at the bottom, you'll see an email from a Mr. Philip Punwar to the courts and copied to Clyde & Co, solicitors for Sunteck, of the 20th of November 2017.
Hold on, not there yet.
Apologies.
No, it's if you use the court's electronic bundle, it seems to take some time to give you the numbers as you scroll down. 554, 574, 555. Sorry, bear with me. I'm nearly there.
Your Honour, I have just tried to share the screen on the case line system. I don't know whether that helps.
No.
Okay.
Five 554. I've got 11/1/29/14 AM, and then I don't seem to have any text on that page.
Towards the bottom of that page, you're right at the bottom.
I've got Philip Punwar, yes, 11:24 AM.
Yes, on the 20th of November to the court and to Sunteck solicitors, saying, "Dear Registry, we write to address matters arising out of the Court of First Instance's judgment." Yeah. And Your Honour, you'll see at the top of the next page, there's a reference there to permission to appeal. There's a request that the lower court gives directions for the making of an oral application for a leave to appeal, together with an application for a stay of the proceedings. Your Honour, there's then a paragraph dealing with costs, and then Your Honour, halfway down the page at 555, under the heading Form of Order, you'll see that it said that in its application, the claimant has sought to prevent the first respondent acting on the notice of the 8th of October. The draft order does limit itself, I think that means should read, does not limit itself to the operation of the notice and prevents any further operation of the escrow agreement. And then the second respondent submits the correct wording as follows.
Yeah.
And then down the end, we've got further directions for the hearing as may be necessary. Ms Sheffield refers to that in her evidence adduced in respect to this application, but says in short that it's not clear, or she can't work out what, if any, directions were provided. But Your Honour, if I take you then to your judgment, or sorry, back to the order which followed your judgment, you'll find that at C22,
yeah.
And if you look at the top of C23, you can see the preamble which says, upon reviewing the correspondence received from the parties dated the 19th of November and the 20th of November 2017, the order is made at paragraph 4, the injunction order. But Your Honour, if I ask you to turn to C26, which is the schedule of reasons,
yeah.
Does Your Honour have that page which has at paragraph 3?
Yeah.
The objections taken by the second defendant amounted to fresh arguments against the continuing order, which are abjured at the hearing, and not simply to the form of the order made. The objections were thus groundless, and it's appropriate the order should take the form proposed, subject only to the issue of costs, which was separately argued. And Your Honour, there has been, as I understand it, no appeal of your decision. And although Ms Sheffield says that an email was written by the predecessor firm to the court in relation to directions, the injunction was not conditional upon particulars of claim being served, or that a form of substantive relief in the DIFC should be sought. And indeed, the court was made very aware at the return date hearing of the two options or potential options that we looked at, which included pursuing the arbitration route.
Yes, I mean, I think, again, you weren't present at the time, but I don't think anybody had in mind any restriction on the court's power to act in support of foreign arbitration proceedings. The point just didn't arise.
Your Honour, that's how I understand it, and I think, as I set out in the skeleton, the application for the injunction was not made pursuant to those provisions. It was made pursuant to the fact that this court had jurisdiction.
Yes.
As Mr Doherty has alluded to, under Articles 5A, I think 1 and 2, and that was the jurisdiction peg that allowed the injunction to be made, and it was made because it was appropriate and just and convenient to do so.
Yes.
And Your Honour, perhaps I could just finish on that point, which is that because Grand Valley knew from that skeleton that it was an option, that instead of pursuing relief in the DIFC, that relief would be sought in the arbitration and relevant facts determined, it was open to Grand Valley then at that stage to say, well, Judge, if they don't pursue any substantive relief in the DIFC, would only go down the arbitration route, then look at the dear authority. This arbitration is foreign seated, and this court doesn't have jurisdiction. Now, of course, the court, in any event, contrast to Deere, did have jurisdiction and does have jurisdiction by reason of Tamimi being a DIFC entity, and also by reason of the express provision in the escrow agreement that the DIFC courts had jurisdiction. So Mr Doherty's, his client's argument that we haven't outlined or set out why the court has jurisdiction to grant an injunction in support of foreign arbitral proceedings, we say is irrelevant, because that's not the basis upon which it was made. The court and Grand Valley knew of the potential option. And in any event, Your Honour, as I've said in my skeleton in a number of places, our position is that the outcome of arbitration 1 is very likely to resolve the issues in relation to the escrow agreement. There is always a chance the tribunal may decline to deal with the fundamental issue in the arbitration, or one of them, which is, whether a contractor was appointed and therefore whether or not we say the obligation under the funding obligations wasn't triggered. But it's very likely they will deal with that point. And Mr Doherty submits today that the arbitration he described it in different terms. First of all, he said the arbitration was not going to have any bearing on the escrow agreement points. Then he said it would have no effect in the DIFC. And Your Honour pushed Mr Doherty in relation to that matter, and he confirmed his client's position that it would have no effect or direct bearing. It wasn't clear, because it wasn't asked of Mr Doherty specifically, what about the other way around? So what happens if Sunteck lose in the first arbitration and the arbitrators find that the obligation under 5.2c was triggered, despite there being no contractor appointed? But subsequently, Mr. Doherty submitted that if Sunteck were to lose the arbitration, then there is no basis for the injunction. And my lord, it's difficult to see how Mr. Doherty reconciles those two. The arbitration plainly is relevant because it deals with the underlying matters under the escrow, which is whether or not there's been a long stop date or been a valid notice. And of course, one of the questions under the escrow, which you alluded to, Your Honour, was whether or not evidence had been provided by Sunteck in response to the notice. And you may recall that Baker McKenzie, who were the solicitors for Sunteck at the time, amongst other things, informed Tamimi that there was no contractor appointed and that the funding obligations therefore hadn't been triggered, and therefore they couldn't provide any evidence as such as of a negative. But in our submission, the outcome of the arbitration and the findings of the arbitrators are relevant, and that it would be then at that point the parties would liaise and consider whether or not and how that impacts upon the injunction. And Mr. Doherty refers quite rightly to the fact there was a second arbitration. Your Honour is aware from reading Mr. Hutchinson's witness statement that there's been an application essentially to strike out those proceedings on grounds of abuse and lack of jurisdiction and so on. It was our understanding that the second arbitration was effectively pursuit of the original counterclaim. Yes. And Your Honour, the original counterclaim was is dated March 2020, and Your Honour, that counterclaim is in the bundle that it begins at F775. But specific relief is sought or was sought by Grand Valley in relation to the escrow agreement. And if I could ask you just, for example, to look at F807.
Yes. Yeah.
You're at paragraph 9.7, you'll see the heading claimant's frustration of release of the shares by Tamimi. There's reference there to the paragraphs and the mechanisms of the escrow agreement. And then turning over the page at 808, you'll see that Grand Valley alleged that the claimant frustrated the process by refusing to provide the claimant shareholder loan, asserting it had complied with the escrow agreement, and then at little 3, wrongfully initiating the first DIFC court proceedings for the purpose of frustrating the respondent's entitlement to access the pre-agreed remedy. And then by its actions at F, the allegation that in commencing those proceedings, the claimant is in breach of various clauses and annexures and is in breach of the obligation of good faith. Now, Your Honour, those aspects of the defence and counterclaim, the counterclaim was withdrawn, as you know, so not to be determined by the tribunal. And indeed, given the escrow agreement contained the jurisdiction clause, which you had ruled gave jurisdiction to the DIFC, the question of entitlement to the documents would fall to be determined by the DIFC and not by the tribunal. In the second set of arbitration proceedings, Grand Valley claim, as we understand it, damages for compensation for loss of profit, but Ms. Sheffield has confirmed in her second statement that it will not contain the relief in relation to the escrow agreement.
Right.
So, Your Honour, when I said at the outset that Grand Valley's submissions lacks realism, it's because of the point Your Honour alluded to, which is that the outcome of the first arbitration, which will very likely to determine whether or not there was a breach of the funding obligations and whether Sunteck failed to pay either the 35 million or the other 215 million, is plainly relevant, we submit, to the underlying matters in the escrow agreement, and that the outcome of that should inform the parties as to what should happen to this injunction. And Your Honour, the realism is that if the parties can't agree on what should happen to the shares and the injunction after the first arbitration, then substantive relief will need to be sought in the DIFC by Sunteck and or potentially by Grand Valley, because of course, Your Honour, it's open to Grand Valley and has been open since you made your injunction order in November 17 to seek substantive relief in the DIFC in relation to the escrow agreement. And I'm going to show you in a moment a letter that was written by or on behalf of Grand Valley to Tamimi in August 2020, suggesting that such proceedings would be brought.
Mr. Doherty submitted to me that even if you were to win in the arbitration, the effect of the escrow agreement is that the documents should be released regardless, because you've agreed that Tamimi should act on the basis of the agreement, escrow agreement, and the escrow agreement only. And I think it was accepted before me, though I haven't looked at the transcript of the ex parte hearing or the transcript on the return date. I think it was accepted that the matters which were raised in relation to funding, appointment of contractor and so on were not matters which the escrow agent could investigate. And really the only direct point that arose was whether or not evidence had been supplied under clause 4.3 B, I think, is it? Yes. And when I look at the skeleton at H10, the only point that the escrow agent was entitled to consider for the purposes of the escrow agreement was that which is set out in paragraph 5.3, subparagraph 3. Do you have that, Mr. Liro?
Your Honour, could you just tell me the reference again in the skeleton? Did you say 7?
In the skeleton, it's at paragraph 5.3, little 3 at H10 or page 9 of the skeleton itself. If you're looking at it a different.
Yes, I'm looking at the skeleton, yes.
Do you see at the foot of page 8, the underlying issues on the merits are the related issues as to whether then no contractor, no relevant default in funding. Leave aside 3 for the moment. 4, long stop date, not a valid long stop date notice, and it's 3 and 5 which deal with the questions of the evidence that was to be supplied to the long to the escrow agent. And as I recall it, what I thought at the time, and what I'm inclined to think now, is that only 3 and 5 were matters for Tamimi to investigate. Everything else was out with the terms of the escrow agreement itself.
Well,
the question that arises is one of construction, and I'm asking really whether you accept that's the case or not.
Well, I don't think I'm in a position to concede that now, but what I would say, Your Honour, is that the whole premise of the notice is that there's been a long stop date.
Yes.
And as you'll be aware, under the long stop date definition, there has to be defaults in funding payment to the contractor with a capital C. And Your Honour may recall that the notice, I can probably refer you to it if that helps, but the notice on the 8th of October, it's at F143.
Yeah.
Says at little 1 that Sunteck has failed to fund payments to contractor with a little c, and then refers to 3 fairly modest amounts at 2. Now, Your Honour, although the escrow agreement refers in terms to not investigating, if the arbitral award following the first arbitration finds that there was no contractor appointed with a capital C, that there was no breach of the funding obligation because Sunteck didn't owe any of the. If you look at 4.1 of the escrow agreement, you'll recall that there's reference to the evidence being the capital contribution of 70 million, which was paid, and then the second party shareholder loan of 245 million. Your Honour will recall that the plank of the notice was that Sunteck hadn't paid any of the 245, and therefore there was a breach, and therefore they didn't need to investigate that matters, and there's been 3 defaults, and therefore the documents should be released. But if the arbitrators find, as we have invited them to do, that Sunteck were not obliged to pay any of that 245 million, that the reality is, one would hope, that Grand Valley would not pursue its claim or entitlement to the documents, because they wouldn't be entitled to them as there'd been no long stop date, no defaults, and there wouldn't need to be any investigation by Tamimi, because Tamimi would know that they were invalid notices. And
the question still arises, Mr. Liddell, whether in such circumstances, assume that the arbitrators find in your favour on those points, as to whether still under the terms of the escrow agreement, Tamimi would be obliged to release the documents. You've said it's to be hoped that the claim wouldn't be pursued, but supposing it is pursued, why shouldn't they pursue it?
Well, because Your Honour, it would be bad in law and in fact, because there would be no entitlement.
Why would it be bad in law and in the context of the escrow agreement itself? We're back again to the practical question that if you succeed in the arbitration, you succeed in your claim for damages. And you have no need of the shares.
Your Honour, I'm going to come to that in a moment, if I may.
Just focus on the question of construction for the moment.
Yes, but can I perhaps as well, just on this point, even if I'm wrong on the construction, what we mustn't lose sight of here is that this argument would have been open to Grand Valley to advance at the hearing, because it was made very clear, which is why I started these submissions by referring you to the paragraph in the skeleton that one potential route would be to go down the arbitration route and seek relevant facts. Now, Mr. Doherty says to you today, well, the reason why this application was delayed for 3.5 years was because they waited until essentially what he described as the last point, when there could have been close of proceedings. But the reality is that these proceedings, the arbitration proceedings, were brought in November 2018, where the relief was set out. Even at the return date hearing, it would have been open to Grand Valley to say, well, we don't understand this point, that you can pursue any arbitration route, because it's all irrelevant under the construction of the escrow agreement. Your Honour, the effect of discharging the injunction, which is what Grand Valley invite you to do, the effect then of any shares being released, or the shares being released to Grand Valley, would be a forfeiting of the shares by Sunteck. And with respect to Mr. Doherty, and your Honour's comment just now, where I think Your Honour said there would be no need for the shares if we were to be compensated, we don't accept that's the outcome of the arbitration. Because what the outcome of what is being sought in the arbitration is damages for breach of contract. And in relation to the contract, that of course is the JVA, and in relation to the damages, it's essentially to put ourselves in the position, but for the breaches that we say were committed by GV of the JVA, had the development proceeded. Now, Your Honour, if there had been no fallout, and if the development had proceeded and this very successful or well-established development had been built, then we would still have had the shares. So I don't understand Mr. Doherty's submission that because we are compensated for loss of profits, which we say we would have recovered, but for the breach, we don't have any rights to hold on to the shares. We would still be a shareholder of JVCo if the development had proceeded. And there is no explanation given in the skeleton, as far as I recall, from Mr. Doherty, why he says that those shares would not remain with Sunteck. He says today that we've sought no relief in respect to the shares, but Your Honour, nor has Grand Valley.
What's the effect of termination of the joint venture? Each of you has said you're entitled, has indeed terminated it, and entitled a claim in the arbitration you're entitled to terminate. What's the effect of termination of the joint venture in relation to the joint venture company shares?
Well, Your Honour, again, that's another matter to be determined. Of course, as things stand, the tribunal has to determine whether or not it's been terminated by Grand Valley, or we're entitled to termination and damages.
Yeah.
Perhaps I should make it clear at this point as well, because it's convenient to do so, that where Grand Valley submit that Sunteck is seeking to wind up the company, I didn't want to interrupt Mr. Doherty during his submissions again, but Your Honour, that's not the case. Originally in the relief, it is right that Sunteck sought a declaration from the arbitrators that it was appropriate to wind up the company. But at paragraph 16.1 of our closing submissions, Your Honour, which is the 17th of June 2021, Sunteck confirmed that it no longer sought the declaration as to whether it was appropriate for winding up proceedings to take place, or whether Sunteck should be limited to a lesser remedy. You'll also recall, Your Honour, that there has been a second set of DIFC proceedings, so subsequent to the Part 8 claim that we're dealing with, brought by Grand Valley against the JVCo to essentially dissolve the company And Your Honour, you probably will recall from reading Mr. Hutchison's statement that there was initially a default judgment obtained, and that was set aside.
Yeah.
So, Your Honour, what may then happen, of course, after the arbitration award, and you know, after if the tribunal finds the JVA is terminated, the party will need to determine what happens to the JVCO. And you know, if it were to be wound up or dissolved, or to go into liquidation, then of course the shares would still be a valuable asset, the 50% shareholding, to Sunteck, and Sunteck would have rights under the liquidation. And Your Honour, this feeds into the submission that Mr. Doherty made, which is damages are an adequate remedy. I mean, the first point, of course, in relation to that, we submit, is that this was a matter that was open and should have been taken by Grand Valley at the return date hearing. There was, as far as I'm aware from your judgment and from what was said at paragraph 6 about it being unchallenged and a serious issue and so on, no debate or discussion raised by Grand Valley that this injunction shouldn't continue because, you know, if it turned out that the documents were wrongly released, then damages would be an adequate remedy. So that's the first and kind of overarching point. But Your Honour, even addressing the question of damages and whether they're an adequate remedy, it's Sunteck's position that they're not. And one must remember, of course, that the damages relate here to a breach of the escrow agreement and not of the JVA. Shares are, as you know, an asset. The arbitration won't determine what will happen to those. The injunction essentially protects Sunteck's position as a shareholder. And Your Honour, if you were to discharge this injunction, the shares were to be released to Grand Valley, but it then transpired subsequently or was established that they shouldn't have been released. There is, I would suggest, a big question mark over how you would quantify the damages. And the damages here would be the loss of those shares. And the reason it would be difficult to quantify is we don't know what Grand Valley are going to do with those shares. Once it obtains the shares, it becomes the full owner of the JVCO. It can take steps, subject to any, obviously, any steps that Sunteck will seek to prevent them from doing so, whether in arbitration or otherwise. It will have lost its rights attaching to those shares, including in liquidation or in any liquidation. It would lose its right to the current value of the company. Mr. Doherty refers to there being 60 odd million dirham of debts, but of course, as is set out, I think, in the skeleton argument, as a reference to a valuation in 2021 of the land of 157 million. And Your Honour will be aware that one of the matters when considering whether an injunction to be made and the adequacy of damages is whether or not potentially it would be difficult to quantify the damages.
Yeah.
And that's referred to in one of the cases in the bundle at J62. And of course, Your Honour, the other matter is what happens, as Mr. Doherty refers to Sunteck and says, well, they don't have the funds to meet any losses that might be established as a result of this injunction. But what happens if we win at the arbitration, we get an award of damages, but Grand Valley ignores it or doesn't pay it for whatever reason, and we don't have the shares? I mean, Your Honour referred to, I think, in a different context about security, the shares being security. But we don't accept that by claiming compensation in the arbitration, we forfeit our shares. And we submit that if the court were required to consider now at this hearing whether damages are an adequate remedy, and as I've said, that's contrary to my submission that this should have been dealt with previously, damages are not an adequate remedy.
If your claim is your claim in the arbitration was simply for wasted expenditure, reliance loss essentially, then the shares would presumably have to be returned, would they? As I understand it, you've got two claims. One is for loss.
It's an alternative, yes, Jon. I'm just thinking, and that is an alternative. I mean, I'd have to take instructions on that, Your Honour, as to whether I can make any concession to that point. But I mean, the fact remains that the tribunal is having to determine all of these matters, and we don't know at this stage what they're going to determine. So even if Your Honour were to find that, well, if we recovered only the reliance loss, we wouldn't have our shares.
Yeah.
There's still the alternative, as at today and as at the date of their application, that wouldn't be the case, that there would be compensation awarded.
No, I understand that.
I mean, the issue, of course, Your Honour, is that the question as to what happens to the shares hasn't been debated between the parties. It is not a matter that is expressly dealt with in the arbitration, and there's no relief sought by Grand Valley either in relation to the shares, as far as I can recall in the arbitration. And Your Honour, perhaps just as a linked point to this, what Grand Valley haven't done, as I understand it, is come to you today and say there's been a change in circumstance because, you know, the JVA has been terminated, or that the escrow agreement has been terminated. And I don't think Your Honour has referred to or had referred to you today this issue, which is potentially relevant, because on two occasions since the injunction, Grand Valley have written to Tamimi and contended that the escrow agreement has been terminated. And I'm going to show you those documents, Your Honour, but perhaps I can just put it into context as well, which is that you were aware of the delay in three and a bit years since the injunction in Grand Valley making this application. But what Grand Valley has done in the interim period is, one, they've sought to dissolve the JV Co, as you know, in the other DIFC proceedings. Secondly, in March 2020, they, in their counterclaim, as we've looked at, sought specific relief in relation to the escrow agreement, which has been withdrawn. And then they sought to terminate the JVA. And Your Honour, for your reference, that's the 22nd of October 18. So that's just under a year after, or sorry, just over a year.
I'm sorry, can you give me that again?
Sorry, that's 22nd of October 18, which is just less than 1 year after the injunction order. And the reference to that is F605. And then a few days later, on the 25th of October 18, they wrote, and this is at F608, you should find, Your Honour, a letter from HFW, who were the solicitors who took over from Baker Botts and prior to Charles Russell. Your Honour, do you have that? It's a letter of the 25th of October 18 from HFW to Tamimi.
Bear with me. Yeah.
So this is 3 days after the letter that was sent to Sunteck purporting to terminate the JVA. They write to Tamimi and give notice of termination of the escrow agreement. And you'll see that they refer in the third paragraph to a DIFC judgment of the 16th of September 2018, ordering that the JVCO be dissolved. Pausing there, as you know, that was subsequently set aside.
Yes.
And then they refer to the letter of the 22nd of October giving notice of termination of the JVA. And they say toward the bottom of that page, in circumstances where the JVK is now subject to the court order and the joint venture agreement stands terminated, our client does not consider the continued appointment of an escrow agent to be necessary. Pursuant to clause 6, you're notified the escrow agreement is terminated at law with immediate effect from the date of this notice. And in light of the foregoing, arrangements will now need to be made in respect to the documents, and we invite you to provide your agreement to deliver up the documents to the custody of the DIFC court. Should you fail to do so, should you fail to agree, we're instructed to commence legal proceedings against you to compel the delivery up of the documents to the court and to seek any other relief as may be necessary in order to protect our client's interests. And that was responded to at F623.
Can I just, this letter's addressed to whom?
This is to Tamimi. So this is from Sunteck's solicitors, Grand Valley's former solicitors to Tamimi.
And was it copied to?
It was. If you look at the bottom right of page 609, you can see it's CC'd to Sunteck Lifestyles.
Yeah. Okay. Yeah. Yeah, and the reply you say is at 6.
As a reply, I mean, there was a reply from both Clyde and Co, but also from Tamimi. If I could just take you to the Tamimi reply, it's at F623. So, Your Honour, this is a letter from Tamimi to Clyde and Co, who are acting for Sunteck, and HFW.
Yeah.
And you can see that at the time, Miss Sheffield, who's now at Charles Russell, was at HFW. Referring to a letter from HFW and a letter from Clyde and Co. Your Honour, I think I misstated by saying that Clyde and Co responded to HFW. Clyde and Co wrote to Tamimi in response to this letter from HFW. But what Tamimi says, the firm is bound by the order of the judge dated 21st of October 17 and the order 16th of November 17. And then turning over the page, the delivery of the escrow documents demanded by HFW is prohibited by the order. Unless the order is discharged or varied to permit the release of the documents, this firm cannot deliver up these documents. Yeah. We refer to the escrow agreement, and it confirms that underneath we will continue to hold the escrow documents.
Yes.
And Your Honour, I can't immediately lay my hands on the response from Clyde's, but I'll try and get that for you. But my recollection is that they confirmed that in their view the agreement hadn't been terminated and that Tamimi could not release the documents. So that was in August, that was in October 18. And then on the 24th of August 2020, so just under 2 years later, Grand Valley, having not made any application to the DIFC or pursued or brought any substantive relief against Tamimi, they wrote to Tamimi at F568 So you should find, Your Honour, at 568 a letter from HFW to Tamimi.
Yeah.
So, Your Honour, this is dated the 24th of August 2020. And it's copied to Sunteck Lifestyles Limited. And you can see it refers to the escrow agreement and the documents being held pursuant to the order. It says there's now been in excess of 2.5 years since the injunction was ordered. And at the bottom of 568 says Grand Valley's recently had cause to revisit the events of October 17 concerning their issue of the long stop notice and Tamimi's subsequent actions. And it goes on to the top of the page to say, of the next page, ATCO, so Tamimi, was obliged to release the documents to our client on the business day following expiry of the notice, but rather than doing so, ATCO acceded to Sunquest's request it be permitted a further period of time to provide evidence. Our client considers that ATCO erred and permitted this further chain of inquiry in light of 2 clauses that they set out there. It says no variation to the notice period is agreed or proposed. The document should have been released. And then about halfway down that page at 569, it says, in light of the above matters, our client considers that ATCO failed to perform its obligations in accordance with the terms of the escrow agreement. However, in circumstances where it has not been open to our client by virtue of the injunction to require performance of ATCO's obligations in accordance with clause 4.3b, the only option which remains available to our client is to terminate the escrow agreement. And just pausing there, Your Honour, that of course was not the only option available. There were 2 other options. One, Grand Valley could have sought to discharge the injunction as it's doing now if it thought it had credible grounds to do so. But secondly, Grand Valley could themselves have sought substantive relief in the DIFC to seek a declaration that the document should be released. But in any event, they seek to terminate the agreement and give notice of the escrow agreement with immediate effect, and says our client does not consider it to be any longer appropriate the documents remain in Tamimi's custody, where the escrow agreement was never intended by the parties to be an open-ended arrangement, and it's impractical the shares should remain in ATCO's custody indefinitely. And then Sunteck has not taken any steps subsequent to the issue of the injunction to formally prove on a final basis its assertion that the long stop date had not occurred. In circumstances where post-termination of the escrow agreement there's no longer any contractual basis for the documents to remain, arrangements will need to be made for their release. Our client considers it's appropriate the documents be returned to them. So that's back to Grand Valley, on the basis they should already have been in receipt of the documents from you as at the 17th of October. We appreciate that as matters stand, you remain bound by the terms of the injunction. Our client intends to apply to the DIFC court shortly for orders authorising to release the documents into their custody. So that is the 24th of August 2020. The documents obviously still remain without Tamimi. It is not accepted by Sunteck that the escrow agreement has been terminated on the basis of some kind of unilateral termination by Grand Valley, but it does call into question Tamimi's position now, Grand Valley's position as to whether they maintain that the escrow agreement has been terminated. Because on their case, according to this letter, if the escrow agreement's been terminated, they should automatically get release of the shares. And of course, Your Honour, you're not being asked to determine that matter. at least not today. But as I set out in my skeleton, the escrow agreement does not deal, at least not expressly, with what would happen to the documents if the escrow agreement were terminated. But it may well be the case following that letter that what Grand Valley's position is that following a termination, where they say prior to that termination they'd made a valid notice, that is why they should get the documents. And, Your Honour, that rather feeds into prejudice, or the alleged prejudice that Grand Valley say they suffer, or the ongoing detriment. The fact that Grand Valley have waited over 3 years to issue this application, we say strongly militates against the court finding that there is such prejudice that urgently requires the release or discharge of this injunction. What are the material change in circumstances, one might ask? What is it now that Grand Valley point to by way of prejudice that they couldn't point to when they were before you in November 2017? First thing Mr. Doherty says is that the company, JV Co, is in debt. It's indebted to various entities in the sum of about 60 million. As I understand it, at least the majority of those debts were in play or there as at November 2017. The second is that Mr. Doherty suggests that because a security for costs order was made in the arbitration, that Sunteck's financial health is somehow relevant to this application. But it is not clear in my submission why Grand Valley were not in a position to make submissions about Sunteck's financial health on the basis of its accounts, on the basis that it receives funding from its parent company and it has no assets of its own, as at November 17 return date hearing. It's not understood why, for example, fortified undertakings were not sought at the time, if that was considered to be appropriate. And Grand Valley also suggests that they need these documents now to mitigate their losses. And the way it's put in the skeleton of Mr. Doherty is it's seemingly linked with the second arbitration. It said that Grand Valley are pursuing a second arbitration against Sunteck, and in order to mitigate their losses, they require the documents. But it's not set out either in Ms. Sheffield's witness statement, so in the evidence, or in Mr. Doherty's skeleton, what it is. What are the steps that will be taken to mitigate their losses if they were in receipt of these shares? And I said in my skeleton that the position remained unclear, and it remains unclear now with respect. And Your Honour, I come back to what I said at the outset, which is that one must look at the reality of the situation. The reasons why the injunction were granted at the time were to protect Sunteck as shareholder from the shares owned or in Sunteck's name being released to Grand Valley. The points made about how the escrow agreement is such or should be construed so that Tamimi should release the documents were all available to Grand Valley at the date of the hearing. The point about damages being an adequate remedy were all available and in any event not of merit. And what seems to underlay the application is a submission by Grand Valley that this injunction should be discharged because Sunteck have not sought substantive relief in the DIFC. It's quite right, as Mr. Doherty says, that this injunction cannot remain indefinitely. But there was no time limit imposed in the injunction. There are proceedings underfoot, as you know, as we've looked at in relation to the arbitration, that we say are relevant to the matters in relation to the escrow agreement. And that if after the first arbitration, the parties are not able to resolve the position, then no doubt Mr. Doherty can reinstate or bring his application again, or substantive relief can be sought either by Sunteck or Grand Valley, or the matter can be resolved, Your Honour, by consent. Your Honour, would you give me 1 moment? Or the matter can be resolved, Your Honour, by consent. Your Honour, would you give me 1 moment? Your Honour, I've got the reference now. If I could just give you that reference to that letter from Clyde & Co. back in October 2018 in relation to the termination of the escrow agreement. It's F679.
Yeah. Yeah.
Your Honour, 2 further points, brief points. The first is that one limb of Grand Valley's application was to strike out the Part 7 claim. That, I think, has now been abandoned because there was no Part 7 claim that was actually issued by Sunteck. It was a system glitch or error of the court. So I think that now falls away, and Mr. Doherty hasn't dealt with it in his oral submissions. Your Honour, the further limb of the application is not just to discharge the injunction, but is an order that you are asked to make specifically that the document should be released to Grand Valley. Now, that is in the application notice, but it is not dealt with, at least not expressly, by Mr. Doherty in his skeleton. We have dealt with it in our skeleton by submitting that on any view is not an order that you are in a position to make, because no substantive relief has been sought to that effect by Grand Valley.
Yeah.
This is not a summary judgment application where the matters have been aired or determined, and in any event it's rather circular, because of course our primary submission is that this injunction needs to be continued for the very reason that underlying issues are to be determined by the arbitrators, and that potentially this court may not need to be troubled again, subject other than obviously by way of consent. And it is not Sunteck's position that this injunction should be permanent or indefinite. There obviously needs to be a further step taken by one or other or both of the parties, and what we submit is that that appropriate timing is after the arbitration award, and that it is just and convenient for this arbitration still to continue. Your Honour, I note the time. We've been going for 2.5 hours. I wonder whether it would be appropriate for us to have a 2-minute break so that I can take instructions, and even Mr. Doherty perhaps can take instructions, whether you'd be amenable to that.
Yeah, well, let's make it 10 minutes, then we can grab a cup of coffee or something.
Your Honour, I'm grateful. Shall we just stay on and just mute and
Yeah, yes, don't sign
Yeah.
out. Either put your camera off or mute or something. And we're 11:34 now. I make it by London time. Let's say 11:45, shall we?
Yes, Your Honour, thank you. We're all back, although you've rather swapped places on my screen with Mr. Doherty, so I need to get my head back into looking at the right person.
Yes, well, it's all moved around for reasons I have no idea about, but I'm sure we can cope.
Your Honour, I've just got, thank you for the short job. I just got one final point, which really relates back to something that you said to Mr. Doherty earlier on today, which is that the JVA and escrow agreements, albeit separate agreements, there is an overlap and they are interlinked. And one of the problems, as you alluded to, is that one has an arbitration clause seated in Singapore and the other has a jurisdiction clause in the DIFC. And as I said in the skeleton, various antecedent issues are being dealt with and to be determined in the arbitration. This is not a case where we are submitting to you that there could never be any need for us to seek any substantive relief in the DIFC.
Well, there's got to be a solution in the DIFC at some point.
Precisely. Mr. Doherty refers to the American Cyanamid Principles, permanent injunction, or so on. And although it is right that we have pursued relief in the arbitration route, and I have said in my skeleton that it's hoped that it's capable of being resolved, it may not be resolved, and therefore the court will need to be troubled again by way of substantive proceedings. But just the final point I wanted to make on that with regards to paragraph 42.5.1.3 of Mr. Doherty's skeleton. I'll get you the reference.
Right. 42.5.1.3, yes, I have it.
And I'm just getting the reference myself. You beat me to it. Yes. Where Mr. Doherty says that C confirms that it has, following the injunction, never issued proceedings by way of Part 7 nor ever sought to do so. In the same paragraph, Mr. Hutchinson expressly confirms that claimant has no intention at all of raising any proceedings in the DIFC court. And by reference to the same paragraph, I take it to be a reference to paragraph 5b, which is in brackets just before that. And that's at E tab 319. So that's E19 and its listed B.
Yeah.
You want to, perhaps I could just ask you to read that to yourself.
Yeah.
So Your Honour, it might be that what Mr. Doherty is relying upon there are the words, there's no procedural requirement or reasonable expectation the claimant must seek such final relief. But Your Honour, if it is being suggested that Sunteck has ruled out any potential to pursue substantive relief in the DIFC following the arbitration award, that would be wrong. Because as I said, and this injunction can't remain indefinitely, and although there was no condition of this injunction that substantive relief had to be sought in the DIFC, of course the DIFC made the injunction order. We submit, as I've already set out in the skeleton, that matters in the arbitration that are to be determined will be relevant. And if this is not capable of agreement between the parties, then either Mr. Doherty will be returning seeking to discharge the injunction or to seek some form of substantive relief himself on behalf of Grand Valley, or Sunteck will be required to seek substantive relief. And Your Honour, unless there can be a further assistance, those are Sunteck submissions.
It seemed to me, and I mentioned this at an earlier point in discussion with Mr. Doherty, I think, that if I was to find that the injunction should continue, there ought to be some provision that effectively stayed the proceedings until the arbitration had concluded, or until further order with liberty to apply, so that it simply isn't left open-ended. But what had been envisaged, I think, at the outset was that the matter would either be resolved by the arbitration and then come back to the court, or the parties would agree that it be resolved in the court instead. But in fact, nothing has happened since January 2000 and whatever it is, 18, isn't it? And that is inherently unsatisfactory. There ought to be some direction as to how matters are or are not to proceed. I take it that if I'm with you on not discharging the injunction, you would be content for there to be a stay on terms that either party can apply to lift it, or otherwise pending the resolution of the first arbitration and or the second arbitration. I'm not sure which it would be.
Well, as to the second, Your Honour, we still wait the determination of the application, as you know. As to the first, we have been, I think the parties have agreed, and the tribunal, that they will provide their award within 3 months of the final submission. So it's hopeful by October. Mr. Doherty is right to say that that award is going to be a partial award on liability, and there may be some quantum issues that need to be resolved. Yeah. But certainly it's expected that the liability issues, so the key question here as to whether or not there was a breach of funding obligations, will be determined and hopefully handed down, or decision awarded in October. As for the second arbitration, it really depends upon what will happen in that application, and whether or not Grand Valley decide to pursue those proceedings in light of what happens in the first arbitration. So Your Honour is right that if this injunction is to continue and the court were to order some form of stay until the first arbitration is concluded, there would need to be some form of provision, I think, to cater for the position that the first arbitration doesn't deal with all the matters, or that Grand Valley, or the position can't be agreed between the parties.
Well, I give liberty to apply. So liberty to apply would enable the parties to come back if something unforeseen happened, or if nothing happened, so that the position can be reviewed. but self-evidently there'd need to be some sort of reason to come back to the court. We can deal with that as and when I've heard all the reply from Mr. Doherty and come to a view.
Yes, Your Honour. We would have no objection in principle to that. Effectively, the order that you made was that any party can seek to vary or discharge.
Yeah.
Just happens to be that Grand Valley made the application a number of years later.
Yes. Yes. All right. Nothing else?
No, Your Honour. Thank you.
Thank you. Mr. Doherty?
Yes, Your Honour, thank you. A few, I hope, reasonably short points in reply. One relates to the point raised by Your Honour earlier in respect of what the practical effects of the injunction being lifted would be. On that, it might assist to take Your Honour to a couple of the documents which should hopefully clarify that a little bit. First, the escrow agreement.
Yep.
At A97.
Yes.
And it's recital B, which refers to what the documents that are held by Tamimi are to be. So it's share certificates, but it's also a board resolution and a power of attorney. Unfortunately, the escrow agreement that's in the bundle doesn't. It has the cover pages, but not the documents that underlie that. But if you go to A13, which is the joint venture agreement, that should explain what will happen effectively. So it's clause 5.3, which relates to payment default, and specifically it's 5.3.3.
Yes.
The substance of this continues into the next page, really, but it deals with a provision that in due course there will be a second party shares escrow agreement. And what that says is that when you get the share certificates, because you've got the power of attorney, the board resolution, those effectively lead to the transfer of the shares over to the other party. So the purpose of the power of attorney is to allow the share certificates to be transferred from being in the name of Sunteck to Grand Valley. So the combined effect of the documents would be to give some actual control over the JV co. So it's not immaterial that you would just be getting share certificates that you can't do anything with. It's more than that.
The power of attorney is a power of attorney given to Tamimi, is it, to execute a share transfer with a board resolution from
the JV co.
No, from these are shares in the JV co.
Sorry, yes.
So presumably it's a board resolution of Sunteck, is it? Must be a Sunteck board resolution and a power of attorney given to Tamimi, so that they can execute a share transfer. Yes. So the certificate goes to the right people.
Yes.
I would assume. Yeah. Okay.
Yeah. So hopefully that should clarify that point. The next point is that Mr. Liddell suggested early on in his submission that the court has jurisdiction in this case in contrast to the Deere case because Tamimi had been a party to the escrow agreement. We say that submission doesn't work because the jurisdiction against Tamimi in that context can only arise under the escrow agreement itself, not under the joint venture agreement. So Sunteck cannot maintain an injunction against Tamimi purely on the basis that there is a underlying dispute under the joint venture agreement. It has to show that there's a serious question under the escrow agreement. So this isn't a case that stands in contrast to Deere. It's just that there are two strands to this. Is there a serious question under the escrow agreement? And if not, Deere applies to say that you cannot maintain the injunction in support of the arbitration because the seat is in Singapore. that I think feeds into one of the observations Your Honour made about what was accepted about the effect of the escrow agreement at the ex parte hearing, and whether Tamimi actually had any ability to look into the underlying merits, and whether there was actually any dispute about that. This is simply if it assists, Your Honour, but I have a page reference for the transcript of that hearing, and it's at F517.
This is of the ex parte hearing or the...
This is the ex parte hearing.
Yeah.
But that extract seems to be getting at what Your Honour was discussing earlier, which is, well, even if you're right in the underlying arbitration, can Tamimi do anything other than release the share certificate to Grand Valley anyway? So at 517, you'll see there's a discussion about whether or not there was actually any discretion for Tamimi to extend the 7-day period for the provision of evidence.
Which is the point that the Holman's letter took, that we were looking at a few moments ago.
Yes, and it's why we say there's no serious question to be tried, because even if you do get a decision on a host of underlying issues which have some connection to the escrow agreement, it doesn't change the consequence of what will happen once the injunction is lifted, which is that Tamimi are bound to comply with the terms of the escrow agreement. They find that there's been a compliant notice and that no evidence has been provided within the time period specified. So on a strict interpretation of that agreement, they have to release it. And it's interesting that Sunteck has suggested that, well, we'll get the decision maybe in October, maybe later on the arbitration. It may be that some of the issues which are connected are resolved. It may be that they're not. And if they're not, then we're going to have to come back before the DIFC for some kind of resolution, because ultimately this issue needs to be resolved as Sunteck accepts before the DIFC court. But what we've not heard is what its explanation of its case could be under the escrow agreement. The terms in my submission are pretty clear, and Tamimi's obligations under the strict terms of that contract are pretty clear, and Sunteck hasn't really offered a viable explanation of why, under the terms of that agreement, either Tamimi ought to retain the documents and not release them, nor has it explained why the documents ought to be released to Sunteck.
Yes.
And again, that once again feeds into this question of whether there's a serious issue to be tried, because Sunteck can't simply hang its hat on the fact that there's jurisdiction under the escrow agreement and then bring a separate claim under the joint venture agreement and use that to sustain it. It hasn't articulated any case in my submission that it has under the escrow agreement, other than alluding to the fact that it might have one in its skeleton for the return date hearing. Feeding into that point as well, Mr. Liddell takes the point that, well, some of these issues ought to have been canvassed at the point in time that the return date hearing take place. But our submission in respect of that point is that what did happen and what inevitably would have happened if these points had been taken at that time is that Sunteck would have pointed to paragraph 13.1 of its skeleton. It would have said, look, we've referred there to a claim that we have in the DIFC in relation to the escrow agreement. That is a serious issue to be tried. We're going to bring that claim in due course, and if we don't, we're going to bring its equivalent in arbitral proceedings. There's no reason to think that Sunteck wouldn't have succeeded on that argument at that early stage where its case was yet to be formulated. And if that happened, one might reasonably ask the question, would that have now precluded Grand Valley from taking the point again? So if we'd made the point earlier and we'd lost, and Sunteck had effectively sat on its hands and not brought the substantive action that it said it was going to bring, in my submission, the point is that that is a material change in circumstance, because it's not, we're not relying on the fact that there is no claim under the escrow agreement, we're relying on the fact that none has been proactively pursued. That's what we say is the material change in circumstance. It's the failure to prosecute, not the underlying point that there's no serious issue to be tried.
Yes.
The next point in reply is that Mr. Liddell made a submission about what the effect of Sunteck's damages claim would be. And it was suggested that if it succeeded, it would still hold shares and have rights under shares, and that there would be some kind of value in that. In my submission, that can't be right, because what Sunteck are seeking from the arbitral tribunals to be put in the position that they would have been if development of the land had proceeded and a tower had been constructed and its units had been sold off. If that had happened, the JV Co wouldn't have had any residual value, because all of the land, all of the apartments, all of the development would have been sold, and the joint venture company would have been wound up. And that's spelled out by the joint venture agreement. It's A31. And clause 25(1)(a), which provides that the JVA remains effective until the development is fully completed, meaning all the units are sold off and the profits have been distributed to the parties, whereupon the JV Co is liquidated. So on the primary claim for damages, which is loss of profit, the position that Sunteck would have been put into is a position whereby the development has been fully realised, profits have been distributed, and then the company is wound up. So actually the position it would have been in is a position whereby it had no shares and the company would no longer have existed.
Yep.
And then the final point that I wanted to address Your Honour on briefly was this idea that the intention was always that the injunction would be premised on the fact that the shares were supposed to be security for the arbitration claim. That is not how the application was put. This isn't a freezing injunction.
No.
It was never premised as such. If it had been, a different standard would have applied. And I don't understand Sunteck to have provided at any point evidence, for example, that there's a risk of dissipation of assets. So I don't think that that analysis works, and I'm not sure that it's something which can properly weigh into the court's consideration on balance of convenience, because if what Sunteck wanted was a freezing order, they should have applied for one. Your Honour, those are the points that I had in reply. Unless there's anything else I can assist with, those are my submissions.
No. You haven't said anything about the application that is made for what's to be done if I'm with you and I discharge the injunction for the actual release of the documents. Is that pursued or not pursued?
Yes, Your Honour. I suppose to be clear, our position is that the order should be made on the terms as drafted. I think for similar reasons to I've already raised in respect of what the effect of the escrow agreement is and what Tamimi can do. The 7-day period has already passed without evidence being provided. There is no other step that Tamimi can take under the escrow agreement, and it seems reasonable to include an order to that effect, because that is the inevitable consequence of the injunction being discharged.
Okay. Right. All right. Well, thank you very much. I shall reserve judgment, but you'll get it pretty smartly with any fair wind. I should draft it this afternoon, but where are we today? Tuesday. You may get it issued by the court before the end of the DIFC week. But if not, it'll be early next week. All right. Thank you both very much. And I hope you have some sort of August break if you haven't had one so far. I always
Thank you, Your Honour.
I always encourage counsel to take a break on the basis that if you don't take it in August, you'll probably never take it. But there it is. All right.
Thank you very much. Much appreciated.
Thank you both very much. If you'd like to sign out, then I'll just have a quick word with the court officers. Thank you very much. And if anybody, that applies to anybody on your team who's with you, whose names I haven't really taken on board.
Yes, thank you.
Thank you.
Thank you very much.
Good day.